Dear friends, welcome back in our channel Indus Lex, and today we are going to discuss the four essentials of the suit. It is our second lecture on Civil Procedure Code for Rajasthan Public Service Commission district judge examination, or we can say a civil judge examination. And in this lecture we are going to discuss four essentials of suit. Number one is parties, number two is a cause of action, third one is subject matter, and fourth one is relief claimed by the plaintiff. Meaning thereby, if any person who is a plaintiff and aggrieved by any situation, may be from act of XYZ, that called defendant, meaning thereby there should be parties in which there is some dispute, and that particular dispute is called cause of action, and that particular cause of action is relating to the particular subject matter. And subject matter we see in the definition that either it is relating to your property right or relating to the right related to the office. And in last, what relief is claimed by the plaintiff, what relief sought by the plaintiff. And in this respect we continue our lecture that the four essential of suits. There must be at least two parties to every suit, namely a plaintiff and defendant. There may, however, be two or more plaintiffs. Similarly, there must be at least one plaintiff and one defendant in every suit. A person is a party to a suit if there is a cause of action against him. The code provides for a necessary party and a proper party, and also contains provision relating to joinder, non-joinder and misjoinder of parties in suit, which we will discuss separately in another lecture. A proper party is a party who, though not a necessary party in a suit, a proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely and effectively and also adequately adjudicate upon all matters in dispute in the suit, though he may not be a person in a favor of or against whom the decree is to be made. The necessary party is one without whom no order can be made effectively, and a proper party is one in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision of the question involved in the proceedings. Where the plaintiff sought declaration of certain rights in a suit on land belonging to state of Haryana, the state of Haryana was a necessary party. The proviso to Rule 9 of Order 1. Order 1 is relating to the parties to the suit, in which Rule 9 says misjoinder and non-joinder of the parties. No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far regards the rights and interest of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of unnecessary parties, meaning thereby this rule is not applicable to the non-joinder of necessary parties. No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interest of parties actually before it. Meaning thereby it is your suit is not going to be fatal. However, the proviso to Rule 9 and Order 1 of the court says that the non-joinder of necessary party would be fatal. It says provided that nothing in this rule shall apply to non-joinder of a necessary party, meaning thereby court may help the litigant where he may misjoin or non-join a proper party, but this rule is not applicable where the plaintiff miss out to make the party to that institution or that person who is necessary party. That the proviso to Rule 9 and of Order 1 of the court provides that the non-joinder of necessary party would be fatal. The petition was filed to challenge the promotion. The candidate higher up in the seniority were not included in petition. Such petition could not be adjudicated upon in the absence of those senior candidates. There is a distinction between necessary party and a proper party. A necessary party is one whose presence is essential and in whose absence no effective decree or order can be passed or made. A proper party is one without whom a decree or order can be passed or made, but whose presence is necessary for an effectual and complete adjudication of the matter. There is difference between the locus and right of impleaded. There is a two right, that locus and right to be right of impleaded, and the two can't be equated. A person having locus may not be denied appearance, but a person who is a necessary party cannot be denied impleadment. Option to participate does not mean right to be impleaded. A person is impleaded or can claim to be impleaded if he has any interest or less. The plaintiff in a suit, being dominus litis, may choose the person against whom he wishes to litigate and can't be compelled to sue a person against whom he does not seek any relief. Consequently, a person who is not a party has no right to be impleaded against the wishes of the plaintiff. However, Rule 10, Sub-Rule 2 of Order 1st of the Code provides for impleadment of proper or necessary parties. If necessary party is not impleaded, the suit itself would be liable to be dismissed. If a person is not found to be a necessary or a proper party, the court has no jurisdiction to implead him against the wishes of the plaintiff. Where in a suit the plaintiff fails to join a person who is either a necessary party or a proper party to the suit, it is a cause of non-joinder of parties, where two or more persons are joined as a plaintiff or defendants. Although they should not have been joined in a suit, it is a case of misjoinder of parties. Order 1st of the Code deals with the parties to the suit, and Order 1, Rule 9 provides that the suit shall not be defeated for non-joinder or misjoinder of proper party. However, it is not so in case of non-joinder of a necessary party. Similarly, no decree may be reversed or substantially varied, nor any case be remanded in appeal on account of any misjoinder or non-joinder of parties, not affecting the merits of the case or the jurisdiction of the court as provided under section 99 of the Code, and we will discuss it earlier. However, this also does not apply to non-joinder of a necessary party. The objections as to the non-joinder or misjoinder of parties must be taken at the earliest possible opportunity, and in all cases at or before the settlement of issues, and if such objection not so taken, it will be deemed to have been waived. With the object of bringing before the court all the persons interested in a suit, so that all the disputes question may be finally decided in the presence of all the parties, the court has been given power to strike out a party improperly joined, and to add parties whose presence the court considers necessary for the effectual and complete adjudication of the questions involved in a suit, enabling the court to decide all such questions without much delay, inconvenience, and expense. The general rule as regards the parties to suit is that all persons interested in a suit shall be parties thereto. An exception to this general principle is formulated under Order 1, Rule 8. Order 1, Rule 8. It provides that when there are numerous persons having the same interest in a suit, one or more of them may, with the permission of the court, sue or be sued or defend such suit on behalf of others also. Ordinarily, a transferee pendent light without leave of the court cannot be impleaded as a party. The lis pendens transferee / purchaser has no right of impleadment. Lis pendens does not prohibit a transfer. It, however, mandates that transferee will be fully bound by decree that may be passed against his transferor. The power of court to add, strike out, or substitute any party to suit is general in nature and discretionary, and is subject to specific statutory provisions. The provision under Rule 10, Sub-Rule 2 of Order 1st of the Code speaks about the judicial discretion of the court to strike out or add parties at any stage of proceedings. The court can strike out any parties who is improperly joined. It can add anyone as plaintiff or defendant if it finds that he is necessary party or proper party. The court under Rule 10, Sub-Rule 2 of Order 1 of the Code will of course act according to reason and fair play and not according to whims and caprices. The main object behind striking out or adding party is to bring before the court all the persons interested in a suit so that all the disputes may be finally determined in presence of all the parties effectually and completely without much delay, inconvenience and expense. The power to add, strike out or substitute any party to suit can be exercised by the court suo motu. Now it is all about the parties we have to study regarding the first essential of the suit. Now we move on. The second essential of the suit is cause of action. Action means a suit, while a cause of action means literally the cause or the set of circumstances which leads up to a suit. A cause of action arises when a legal right is infringed. The expression cause of action as used in the code means every fact which it is necessary for the plaintiff to prove that he is entitled to a decree in the suit. In other words, the media upon which the plaintiff asks the court to arrive at the conclusion in its favor. The term cause of action has not been statutorily defined, although it has received judicial interpretation. The term is held to include all those facts which must be proved or established in order to succeed. To put it differently, everything which is not proved would give the defendant a right to an immediate judgment must be part of cause of action. The expression cause of action means the bundle of facts which gives rise to right or liability. It is a bundle of facts whose proof is a sine qua non for ultimate success in the suit. Whether a particular fact constitutes a cause of action is determined with reference to the facts as disclosed in the plaint and by taking into account the substance of the matter rather than the form of action. It has no relation whatsoever to the defense which may be set up by the defendant, nor does it depend upon the character of the relief prayed for by the plaintiff. A court enjoys jurisdiction in a suit if the cause of action arises within the local limits of its jurisdiction, and even if a part of the cause of action arises within the local limits of its jurisdiction, it has jurisdiction to try and entertain the suit. The provision under Rule 3 of Order 2 of the Code specifically provides where cause of action are united, the jurisdiction of court as regard the suit shall depend on the amount or value of aggregate subject matters at the date of instituting the suit. Every plaint must disclose a cause of action, and if it does not, it is the duty of the court to reject the plaint. Every plaint must disclose a cause of action. If it doesn't, it is the duty of the court to reject the plaint. Order 7, Rule 11. Order 7, Rule 11 says that if plaint has not disclosing the cause of action, it is a duty of the court to reject such plaint. When the plaint read as whole does not disclose material facts giving rise to cause of action which can be entertained by a civil court, it may be rejected in terms of Order 7, Rule 11 of the court. The court cannot dismiss a suit for not disclosing cause of action, but can only reject the plaint. Hence, in a drafting a plaint, one must be very careful to see that the plaint discloses a cause of action. Order 7, Rule 11. Let's see what the Bayer Act says. Bayer Act says that rejection of plaint. The plaint shall be rejected in following cases where it does not disclose a cause of action. where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within time to be fixed by the court, fails to do so, where the relief claimed improperly valued but the plaintiff is returned upon paper insufficiently stamped and the plaintiff, on being required by the court to supply the requisite stamp paper within time to be fixed by the court, fails to do so, where the suit appears from the statement in the plaint to be barred by any law, where it is not filed in duplicate, where the plaintiff fails to comply with the provision of Rule 9. Where is the cause of action in a suit for damages for breach of a contract? In order to answer this question, we must ask ourselves the further question as to what facts must be proved by the plaintiff in such a suit so that he may succeed in obtaining a decree in his favor. I repeat this formulation for your better understanding that question is, what is the cause of action in a suit for damages for breach of a contract? In order to answer this question, we must ask ourselves the further question as to what facts must be proved by the plaintiff in such a suit so that he may succeed in obtaining a decree in his favor. The answer is that there are two facts which he must prove, namely, number one, that the defendant entered into the alleged contract with him and that the defendant committed a breach of this contract. In other words, we can say the cause of action consists of two parts, namely the making of the contract and the breach thereof by the defendant. Both these facts must therefore be alleged in the plaint and they must both be proved at hearing of the suit to entitle the plaintiff to a decree for damages against the defendant. If A enters into a contract with B in Bombay to sell and deliver goods to B in Bombay, but A fails to deliver the goods, the whole cause of action is said to arise in Bombay. If the contract is made in Bombay and the goods were to be delivered to B in Madras and A fails to deliver the goods to B in Madras, a part only of the cause of action, namely making of contract, is said to arise in Bombay and a part so far as the breach is concerned in Madras. In other words, if the contract is to be performed at the place where it is made, the whole cause of action is said to arise in that place. But if it is made in one place and is to be performed in another place, a part of the cause of action is said to arise in one place and a part in another place. Even the performance of contract may be required to be made at more places than one. If A enters into a contract with B in Bombay whereby A agrees to deliver goods to B at Madras in consideration of B agreeing to pay to some other person on A behalf the price of such goods at Calcutta, then the contract is made at Bombay and is required to be performed at by A at Madras and by B at Calcutta. It can be said that a part of the cause of action has determining the court in which the suit is to be instituted. It will be dealt with in later discussion where we will discuss the jurisdiction of the court and the institution of court where the civil cases should be filed or instituted at the first instance. Now let us take the case of tort. If A brings a suit against B for damages for a libel upon A, then A must prove in order that A may be entitled to a decree the following three facts, namely that the writing complained was published by the defendant, that it is untrue, that it is defamatory for A. These three facts constitutes A's cause of action and they must be alleged in A plaints. In case of tort of malicious prosecution, A must establish that the defendant lodged a criminal prosecution against him, that it is terminated in A's favor, and that it was launched maliciously against A without any reasonable and probable cause. To know the essential facts which constitute the cause of action in a particular case, one must have thorough knowledge of the substantive law bearing upon the case. In case of doubt or difficulty, leading cases complied in various textbooks on the subject must be referred to. Before drafting the plaint, one is well advised to look at the substantive law governing the matter. In fact, Without close examination of relevant facts in the context of applicable substantive law, it is highly possible that litigation may misfire. It is recommended that a standard textbook on drafting pleading be referred to before finalizing a plaint in order to avoid any mishappening. Now, after completing our discussion on the two major essential, that first one is parties and second one is cause of action, third one is more important, that is the subject matter. Jurisdiction over subject matter is a sine qua non, without which court shall be incompetent to try the cause. The subject matter of suit is the property claimed in the suit, and such property may be movable or immovable. Now we will discuss the subject matter, and as per the subject matter where the suit can be instituted for the first instance in later lectures. Now we are confining ourselves on the fourth essential, that the relief claimed by the plaintiff. Every suit shall be instituted by presenting the plaint to a court or any officer appointed in this behalf. Every plaint shall comply with the rules contained in Order 6 and Order 7 as far as they are applicable. Order 6 and Order 7. Here we can see Order 7 deal with plaint, and Order 6, which consists about 17 rules, pleading. Order 6 pleading and Order 7 plaint. And it says that the plaint shall contain the particulars. Where we see Order 7, we find that the plaint shall contain the following particulars. First, name of the court in which suit is brought, name, description and place of residence of the plaintiff, name, description and place of residence of the defendant so far as they can be ascertained, facts constituting cause of action and when it arose, facts sharing that the court has the jurisdiction over the matter, valuation of subject matter for the purposes of jurisdiction and court fees, relief claimed. Every plaint shall state specifically the relief which the plaintiff claims. The same rule applies to any relief claimed by the defendant in his written statement. Every suit must, as far as practicable, be framed to provide grounds for final decision on the subjects in dispute and prevent further litigation concerning them, and thus must include the whole of the claim with which the plaintiff is entitled to make in respect of the cause of action, where neither the title of the plaintiff nor previous possession of the plaintiff nor encroachment by the defendants was made out, the suit was held liable to be dismissed. Splitting of claims is barred. However, any portion of claim can be relinquished. Where a question arises as to whether a plaintiff has claimed a particular relief, the court must read the plaint as whole and consider the substance of the matter rather than the form of pleading. Where the suit is for recovery of money, precise amount must be stated unless suit itself is for accounts or main profits or debts which cannot be estimated. In such cases, approximate amount must be mentioned so that reliefs can be claimed simultaneously or in the alternative. In fact, it is convenient to file a suit for specific performance and in the alternative for damages. Where the subject matter of suit is an immovable property, there must be a proper description of such property sufficient to identify it whenever applicable. Its boundaries and numbers in revenue record must be provided. There is a famous maxim, ubi jus ibi remedium, means where there is a right, there is remedy. The word jus has reference to the cause of action, the word remedium to relief. The nature of relief or remedy to which plaintiff is entitled depends upon the nature of his right or his cause of action. So for today, we have seen all the four essential of the suits, and therefore we are stopping our discussion at this instant. In later on, we will discuss place of suing from section 15 to 20, which regulate the venue where the suit can be filed and apply. The important provision regarding this is section 16, 17 and 20 of the code. And after discussion of the place of suing, we will move on a very delicate topic, which is not only important for our competitive examination, but it is most important part because it is necessary to understand the cause of action and relation of that cause of action with the parties. We have already discussed the four ingredients of suits, that is parties, cause of action, subject matter, relief claimed by the plaintiff. And I think in an introductory lecture I told you about the place of suing, where if the movable property is situated in a 3 district, plaintiff may file a civil suit in any of the district of his choice, of his convenience. And at this juncture we can say that the subject matter and the relief claimed by the plaintiff does not require any further comments, but parties and cause of action require a fuller statement, because we have to understand what is joinder, what is misjoinder. As I earlier in the beginning of this lecture I told you that we will discuss these things in details. It is very important for our purpose to note the distinction between an act or a transaction and a cause of action. A cause of action always springs from an act or a transaction. An act or a transaction may give rise to one cause of action, or it may give rise to two or more cause of action. Where there are several cause of action, a separate suit may be brought in respect of each distinct cause of action, though they may arise out of the same transaction. In a suit, the plaintiff is bound to claim the entire relief. A suit has to be so framed as to afford ground for final decisions on the subjects in dispute and to prevent further litigation concerning them. However, one cannot split a cause of action and bring two or more suits in respect of the same cause of action, as laid down in Order 2, Rule 2 of the Code, which centers around one and the same cause of action. The object of Order 2, Rule 2. Let's move on. The Order 2 and the Rule 2. Order 2 and the Rule 2. Suits to include whole claim. The object of the Order 2, Rule 2 of the Code is twofold. First is to ensure that no defendant is sued and vexed twice in regard to the same cause of action. Second is to prevent a plaintiff from splitting the claims and remedies based on the same cause of action. It does not bar a second suit based on different or a distinct cause of action. Order 2, Rule 2 insists upon inclusion of the whole claim which the plaintiff is entitled to make in respect of a cause of action put in the suit. It directs securing exhaustion of relief in respect of a cause of action and not to the inclusion in one and the same action of different cause of action, even though they may arise from the same transaction. A's cab comes into collision with B's van. The collision causes damages to A's cab. Second, bodily injury to A. Here the same transaction, namely collision, gives rise to two distinct cause of action. One in respect of the damage to A's cab, and the other in respect of the injuries to A's person. Here A may bring one suit against B in respect of the both cause of action, though he is not bound to do so. He may, if he likes, bring two separate suits against B, one for compensation for damage to his cab and the other for compensation for injury to his person. However, he cannot bring more than one suit in respect of either of these two cause of action. Thus, if he brings a suit for damages for injury caused to his arms and legs, he cannot bring another suit for damages for internal injury, though he may not have been aware, but when he bought the first suit of such injury. At this juncture, we are stopping our discussion, and when we meet further, we will discuss joinder of parties. All person may be joined in one suit as plaintiff, where the right to relief alleged to exist in each plaintiff arises out of the same act or transaction, and second, where if such person brought separate suit, any common question of law or a fact would arise. That order 1, rule 1. Order 1, rule 1. Joinder of parties. All persons may be joined in one suit as plaintiffs, where the right to relief alleged to exist in each plaintiff arises out of same act or transaction, and where if such person brought separate suits, any common question of law or fact would arise. Both the conditions are cumulative and not alternative, and both must be fulfilled. However, it is not necessary that all the questions arising in the case should be common to all the parties, and it would be sufficient if one of the questions is common to them. Although all the persons coming under this rule may join as plaintiff, the court has power to order separate trials when such joinder embarrasses the trial. It is further immaterial that the plaintiff, let finish this our lecture, otherwise it will take about 1 hour more. We will discuss this topic, joinder of plaintiffs and procedure in case of misjoinder of parties, joinder of cause of action, joinder of defendant and a cause of action, joinder of plaintiff and cause of action, procedure in case of misjoinder of parties and cause of action, non-joinder of parties, effect of non-joinder of a necessary party, effect of non-joinder of a proper party. We will all discuss in a separate lecture and close with the discussion that who is a proper party, and then further we move on the suit. We will trying to learn how the suit is instituted, because till now we only discuss what is the essential of any suit. We discuss what is civil suit. We discuss implied bar on the filing of a particular suit. Thank you.